John O'Keefe was a respected Boston police officer, a man devoted to his badge, his family, and those closest to him. At the center of his life was Karen Reed, a financial analyst with whom he shared a complicated but passionate relationship. Their romance, marked by both affection and turbulence, would ultimately become the focal point of a murder case that has captured the nation. On a bitter January night in 2022, John O'Keefe's body was found lifeless in the snow outside of 34 Fairview Road in Canton. Authorities charged Karen Reed with his murder, alleging she struck him with her SUV in a drunken rage. But Karen Reed and her supporters claim a cover-up, suggesting he was beaten inside the home by someone else. Her first trial in 2024 ended in a hung jury, dividing the public and igniting a firestorm of controversy. Now, with her retrial underway, the courtroom has once again become a battleground, not just for justice, but for truth in a case where love, loss, and suspicion collide. And today, the defense went on the offensive as they tried to raise reasonable doubt. We are live from the courthouse with all the big moments as the retrial of the century continues. I'm Vinnie Politan. Great to have you with us tonight here on Closing Arguments as a new week begins in the Karen Reed retrial of the century. And we're in the stretch. We're in the stretch, we're in the defense case, and this defense team and this defense has a lot of work to do. You know, in some cases, the defense doesn't have to do much. Sometimes they do nothing. A lot of times they lose. But in this case, the defense has work to do because this prosecution in the retrial, different than the prosecution first time around, more streamlined, more precise with their evidence, a much stronger presentation, stronger experts, and they have created a few issues here that the defense has to deal with. So they got a lot of work to do here. One of the big things they have to explain to this jury is how the tail light in the snow, how did it get there? How did Karen Reed's tail light pieces end up in the snow? You've got to explain that. Now, the prosecution has explained their version of how it happened. It was backing up, striking John O'Keefe, hitting his arm, and then it shattered when she was going 24 miles per hour in reverse, and that's how the pieces ended up in the snow, how the pieces ended up at 34 Fairview. And if the jury believes that, that's game over for Karen Reed. That means she struck John O'Keefe. That's what this case is about. That's what the first jury could not agree on. Now, how are they going to do it, the defense, as we're in the defense case? Well, they're going to point the finger at these guys. You've got Brian Higgins, Michael Proctor. You've got Chief Berkowitz, or former Chief Berkowitz from the Canton PD. All these names have come up. And what they have to do is raise to a reasonable degree of possibility, right? Because you only have to raise reasonable doubt. You don't have to prove it. You just got to raise a reasonable doubt that it's possible, that it's reasonable that one or all of these men together took pieces of Karen Reed's tail light from the Sally port and threw it on the lawn on 34 Fairview and put it there to make sure that it was found in order to frame Karen Reed. Now, the defense doesn't have to prove that that happened, but they have to raise the idea of that to be reasonable and not like, come on, are you kidding me, right? They've got to raise a reasonable doubt. So today there was a witness, former Canton police officer, Kelly Dever. Is Dever the key to all of this? And she may very well be. She may very well be because she was a Canton police officer. She made some statements that may very well help the defense to stand in front of the jury at the end of all of this and argue that, yeah, there was a cover-up. That, yeah, there was a witness who saw what was happening. There was a witness who changed their story. And she may very well be the key for the defense. And this is someone who, by the way, didn't testify in the first trial. Let's get to the bottom of all this. Let's bring in Court TV crime and justice correspondent Matt Johnson joining us live from outside the courthouse in Dedham. Matt, wow. Like, I understood that the prosecution case was going to be different. We have some new witnesses, some new experts, etc. But now the defense bringing in a brand new witness. Tell us about this officer who testified this morning. This was some of the most compelling testimony of the trial.
And some of the most heated testimony, and on direct, not cross-examination. Usually we use those two words together when we're saying it was a heated cross. This was a heated and intense direct in this courthouse here behind me. Big day here in Dedham. Kelly Dever, a former Canton police officer who was working at Canton Police, and she was asked to work the call center, or where they had all the monitors. She had access to all of that when this all took place on January 29th, when they brought in Karen Reed's SUV to the Sally Port. And she originally, or at one time, allegedly reported to authorities that Brian Higgins and former Chief Kevin Berkowitz were in the Sally Port near the SUV for a very long time. And then all of a sudden, she now says, quote, it was a distorted memory. Listen to this.
Did you observe something in the Sally Port garage on January 29th, 2022 that you found unusual, that stuck out in your mind?
Given factual information that makes it so I know I did not, no.
So the answer is no.
Correct.
Did you tell those law enforcement agents on August 9th, 2023 that you saw Brian Higgins and Chief Berkowitz go into the Sally Port together and alone with the SUV for a wildly long time?
That was my recollection at the time.
So you did say that?
At the time, that is what I recollected.
Remember, the defense is trying to build a case where they're saying third-party defense, but they're doing it with just naming Albert and Higgins. But in total, they've really said all along that it's a wide conspiracy, that there's a big cover-up here in Canton, and it involves a lot of people. So part of her testimony today, the defense implied that her story had changed after meeting with a very higher up, the police commissioner. Listen to this.
Did you have a conversation with anybody in the commissioner's office at Boston Police Department?
Not about anything malicious.
I didn't use the word malicious. Why do you say malicious?
I had a conversation, but it was my department saying, regardless of what I need to say on the stand, they support me.
Did you tell the defense that when you were called up to the commissioner's office, he told you two things? Commissioner Cox told you, number one, the Boston Police Department supports you, and Officer Dever, do the right thing.
So he said my name correctly. He said Dever, and
That's my mistake. Let's see, like, you want me to repeat the question so I get
So,
that right?
Mr. Jackson, let's go ahead and answer, please.
yes, and he said nothing with the intent of guiding me one way or the
I didn't ask you
other.
what his intent was, madam. I asked you what he said to you. What were his words to you?
That he supports me.
And?
Just wanted me to tell the truth up here.
And his words were, do the right thing, correct?
I don't recall.
She doesn't recall, and she's no longer with Canton PD. She's now moved over to the big city in Boston, where she's now a police officer. But she made it very clear, Vinnie, right off the bat, that she did not want to be a part of this trial. She did not want to be here in Dedham. She did not want to testify. And she actually made that clear on Friday when I saw her in the courtroom. She, of course, a lot of the witnesses, like the rest of the witnesses, they're all lawyered up. She brought her attorney here, and Judge Beverly Cannoni made it very clear that she needed to return to court today.
Yeah, she didn't want to be there. That was super clear. She was working in Canton at the time. She now is a Boston PD, and that commissioner was the commissioner of the Boston PD who had the conversation with her, the defense trying to make the implication that, hey, do the right thing for your fellow officer, right? That's where the defense is going. And she's saying, no, he's just, you know, tell the truth. So it's almost as if she had just kept with the original statement that it would be less damage. Changing the statement almost gives life to the conspiracy inside that courtroom, Matt. And it's really for the first time during this trial that, oh my goodness, like someone is changing their story after speaking with the commissioner, and all of a sudden, what she remembered very specifically, she no longer remembers. It's a false memory. I don't understand that.
Yeah, you know, and the words that she used, again, quote, it was a distorted memory. I've never heard that in my life as a reporter.
Yeah, okay. There was a lot that happened today, Matt, so let's now get to former Trooper Michael Proctor's friend. Again, another witness we hadn't heard before in court today.
Yeah, he was the first witness called today on day 2 of the defense case in chief. So that's Jonathan Diamandis, and he was a childhood friend of former Trooper Michael Proctor. He verified those disturbing text messages that Proctor had sent to him, other friends, and also the co-workers about Karen Reed, this defendant, during the initial part of the investigation. Listen to part of his testimony.
I'm sure the owner of the house will receive some.
And could you read Mr. Proctor's 2 responses?
Nope. A homeowner is a Boston cop too.
Could you read Mr. Proctor's 2 comments?
She waffled him. I looked at his body at the hospital.
And one of the group asks a question.
She waffled him, in quotation marks.
And how does he respond?
He was banged up.
Somebody in the group asks another question. What do they ask?
I thought he was drunk. Did he get beat up?
And Mr. Proctor's response?
Nope. So the owner of the house was a woman cop that beat him?
And Mr. Proctor's 2 responses?
That's what I initially thought after talking to Canton paramedic. Then I saw the guy.
So one of the group asks, what does, quote, she waffled him, quote, end quote, mean? And then asks, what's the story? Does Mr. Proctor return?
He does.
What does he say?
She hit him with her car.
How does Mr. Proctor respond?
Intentional or not.
And somebody in the group again?
Gotcha. He was frozen in the driveway and she didn't see him.
And Mr. Proctor's 2 responses?
That's another animal we won't be able to prove.
And the next one?
They arrived at the house together, got into an argument. She was driving and left.
What does the friend say?
What's the name of the Canton cop living in Canton? The other one involved.
What does Mr. Proctor say?
Biffed him.
January 29, 2022, 11:02 p.m. and 15 seconds. There's a comment from one person in the group, number ending in 5051. Could you read that?
But I assume you guys are out to make it cut and dry since it involves cops?
Next comment by Bird.
Something stinks.
And the comment by Mr. Proctor.
Yeah, but there will be some serious charges brought on the girl.
Again, it's a brand new witness that we didn't see during the first trial. The second trial, this friend of Proctor is brought in to verify those text messages that he really had no part in. He only replied to one of them, Vinnie. And then the defense fights and fights to get these text messages into evidence. He just verifies them on direct. And then you hear right now that it's the questioning of Hank Brennan on cross where the text messages are read in open court.
Again, very bizarre, strange moment, but it happened, and it all happened because Trooper Proctor, nobody's going to call him. No one. All right, let's get to the dog bite expert. This was a lot of pre-trial litigation about this. How did that go today?
Yeah, so Dr. Marie Russell, we all remember her from the first trial because halfway through the trial, she contacted the defense team last year and she said, I happen to be a dog bite expert. I have a medical degree. I work in Los Angeles. I used to be a police officer and I'd like to help you out. Well, she testified last year. There was a voir dire then. There was a big fight pre-trial for the retrial. She was voir dired again, and today she was finally brought before this jury. And she concluded, like she did in trial number 1, that those injuries that you're looking at right there on Officer John O'Keefe's arm, she believes that that is from a dog attack. Take a listen.
Based on your review of all the materials that you had described and your experience that you had described, without stating it, were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack.
Now, the day ended, she's on cross-examination, and no one is saying that she is not very qualified. I mean, she's a medical doctor. She spent nearly 3 decades doing that. She was in law enforcement before that. She works at one of the biggest hospitals on the West Coast in Los Angeles. I mean, when you hear the word General Hospital, it's actually the front of that TV show, General Hospital. That's where she works. It's a huge, huge facility there in Los Angeles, and she was head of that, one of those divisions. But she's going to be back on cross-examination tomorrow, and she left the stand today. One of the last things that she said, Vinnie, was she was talking about the fact that she has never testified in a criminal case before as an expert on a dog bite.
That's good. That's good cross-examination. Let's talk about this. This was a big Monday, right? This is a big start to this week. There's a lot happening inside the courtroom. Any reaction afterwards, Matt?
Yeah, so Karen Reed, again, I have to remind the viewers that none of the attorneys this time around are able to speak. They're all under gag order. They just say hello and goodbye when they exit the courthouse here behind me. But Karen Reed, laser focused on answering questions about that troubled witness today. Take a listen.
Karen, are you suggesting that Deborah may have been coaxed into changing her testimony?
Yes. What's your reaction to her demeanor? I didn't suggest it. She did. When she was called into the commissioner's office, the story completely changed and it was recanted. So I don't think it was a suggestion. I think I heard what you heard.
But wasn't she confronted with data from the FBI that said, no, you weren't, the car wasn't there by the time you left?
This is the first I've ever heard that. I have no knowledge of anything like that.
Did you expect her to be like that on the stand?
I've never seen, met, or heard her voice before, so I didn't know.
What's your response to her accusations of pressuring her to perjure herself?
We subpoenaed her to testify to what she told other authorities and just wanted her to be as honest with us as she was with them. And today she's now telling us that was a lie. So we just wanted her to repeat what she told other law enforcement agencies under penalty of perjury. That's all. Thank you. Thank you.
You never told her to lie?
Never.
And that was it. This defendant, again, the only one able to speak, and she usually does each and every day as she exits the courthouse. She says that her case on track. She believes that it's going to be projected at a week and a half, maybe 2 weeks. But those statements, the jury's not hearing it. And that's a big difference, again, with the retrial and the first trial, Vinnie, is we still have every single person that was impaneled in the first place. We have the 9 men and 9 women that are still in the box. That were selected nearly 2 months ago for some of those folks. We have not lost any of the jurors just yet. And last year, by this point in time, I think we lost 3 or 4.
Yeah, we did. Well, that's good. They're all healthy, and no one is tainting them, which is good. Matt Johnson on a big Monday. I'll speak to you on Big Tuesday. Thanks so much. All right, let's bring in our think tank. Criminal defense attorney, former prosecutor Al Wunsch III. Criminal defense attorney Darnell Crossland, and Paulette Lofton, chief public defender for Oakland County, Michigan. All right. Al, did Officer Dever, by changing her original statement to the FBI, jury isn't told it's the FBI, it's some mystery law enforcement agency, but by changing the original statement and saying it was like a distorted memory, did she plant the seeds for the conspiracy now for the defense?
I don't know if she did, if that is going to be enough to put that over the edge. I thought she held herself together pretty well on the stand. I mean, this distorted memory or an inaccurate or illusionary recall or recognition of past events was, certainly a bizarre term to be thrown out.
Bizarre, beyond bizarre, Al. That's like she said, very specific. I saw the chief, I saw Higgins, and they were in there, and she noticed it. It wasn't, and they were there for quite some time. Like she actually noticed it. Where did that come from?
Well, according to her, it was an illusion and it wasn't necessarily the accurate based on the facts that she has been able to review since then.
So she impeached her own statement with the facts.
Well, she did impeach her own statement, and I mean, and she, you know, and what was interesting is they didn't try to get her as a hostile witness. They stayed with her as a witness on that, which was, I thought, a mistake. I thought they should have converted her to a hostile witness and gone after her with being, you know, asking leading questions that would have really pinpointed her a lot better, I think.
Yeah, but Darnell, we're in a strange place here. Like, you saw something and then you didn't see it because of someone showed you a timeline or something. I don't understand how you imagine seeing that.
Yeah, well, first thing, if you look at something that's distorted, it's crooked, right? It's blurry. You really can't see. We don't want to go to the movie theaters and see a film that's distorted, right? We want a clear picture. So clearly she just said to this jury, my memory is not clear. My memory is crooked. This case sounds crooked. And I do believe that the defense scored some points here because she wanted to focus on things about how her name was pronounced. How many times do you have to tell a person in your normal day-to-day life, please just tell the truth? You assume that they're going to just tell the truth. So this big meeting is called with these big higher-ups. And she wanted us to believe that the real meeting was just called so they could remind her just to tell the truth. So I think the jury's going to be able to see through that. And I think that she didn't help the prosecution's case. I think she actually hurt the case.
Yeah, and the homeowner, Brian Albert, is a fellow Boston police officer, by the way, as was John O'Keefe. Paulette, would the prosecution have been better off if she had just not recanted her statement? Like, to me, it's worse that you're saying, I said that, but it was a distorted memory, and now I'm saying this, and this is the... It just raises that everything that the defense is alleging here, that it's just not right.
It drew so much attention to her previous statement because of her demeanor. It seemed as though she had a rehearsed answer for every single question. And if she didn't like the way the question was asked, she answered the question she would have wanted it asked. So I do think her demeanor today on the stand, the way she just had issue with the pronunciation of her name and the way questions were asked, I do think it drew a lot more attention to a fact that may not have been as consequential as it may now be. I do think with her false memory and the way she explained what she originally said, that to me is very strange. Maybe a false memory of, I was there at 6 a.m., but then I was shown a video of me pulling out, so it couldn't be true. It was such a detailed statement that she made that she even characterized the two individuals in the Sally Port for such a long period of time. She said it was wildly long. That is something that you firmly remember. I don't think that is a false memory.
All right. Think Tank staying with us. When we come back, we're going to get into the dog bite expert, plus coming up next hour. Tonight on Vinnie Politan Investigates, the biggest difference between the first and second trial of Karen Read is that the jury has heard from Karen Read, as the prosecution has played chosen portions of her media interviews. Did she admit to seeing John O'Keefe on the ground before she left 34 Fairview? We investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, tonight, 9/8 Central, only on Court TV.
What do we really know about Diddy parties?
Get a new look at the evidence and the latest from inside the courtroom. Vinnie Politan Investigates, a Diddy special report, Wednesday night, 9/8 Central, on Court TV.
Were you able to come to any conclusions or opinions about the source and nature of the injuries that you see depicted on that exhibit?
Yes.
And what is your opinion and conclusion concerning those injuries?
Those wounds were inflicted as the result of a dog attack.
That is the testimony of the dog bite expert for the defense. They are saying the wounds on John O'Keefe's arms, not from a shattered taillight, but from a dog attack. So the expert testified on direct, and that's how things went as planned. But the true test of any expert or any witness is cross-examination. So let's see if Dr. Russell survives cross.
Before this case, had you ever testified as an expert in dog bites in any federal court in the United States?
No.
Before this case, had you ever testified in any state court in anywhere in the country as an expert in dog bites?
No.
Other than this case, have you ever testified in a courtroom as an expert about dog bites?
No.
You wanted to get involved in this high-profile case, didn't you?
No.
Well, you weren't called by anybody on the defense and retained as an expert in the traditional sense, were you?
That's correct.
It was after you reached out yourself and interjected yourself into this case, true?
I did so for a reason, and the reason being that I knew I was one of the only people in the United States board certified and residency trained in emergency medicine and also residency trained in forensic pathology, and therefore I had a unique skill or knowledge set, and I was one of the very few people that had the knowledge of dog bites, as well as those other trainings.
Did you say today and before, have you said that you believe you're one of the only few physicians in the United States who could authoritatively distinguish between causes of wounds when it relates to dog bites?
I did say that, and that's because of my unique training. I don't know of another doctor in the whole United States that did 2 residencies, one in emergency medicine and one in forensic pathology, and has a lifelong interest in dog bites.
So, Dr. Russell, from your perspective, as far as you know, you were the only person in the entire United States of America who is qualified to look at a photograph and make a determination whether the wound was derived from a dog bite.
No. I am I'm the only physician that I know of that can do that. There may be, a few others out there. There may be, but I don't know of any other physicians that can do that. If a forensic pathologist has autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not so sure that person would be a very good expert in that kind of a case.
Dr. Russell, I read to you the measurements that were in Dr. Scorti-Bello's report. Are you aware that she testified that these superficial abrasions did not have any depth or any puncture?
I don't recall that.
Would you agree that the superficial abrasions on Mr. O'Keefe's arm had no punctures?
I agree.
Would you agree that the abrasions, the superficial abrasions on Mr. O'Keefe's arm had no depth?
No measurable depth, yes.
Did she survive cross-examination, Darnell?
Well, when you have to, as an expert, have to sing your own song, that's not looking too good. So I didn't like that. I didn't feel comfortable with when she had to talk about how she's such an expert. Her testimony, she showed how she's an expert. And then the depth, when a dog bites you, or when you bite into your bagel, if you don't break that crust and have some depth, then I don't know if that's a bite. So that didn't feel too good. So I think she took some blows on that one.
Paulette, your thoughts?
I thought she did well. I think the Commonwealth was in the weeds about how many times she has testified or if she has ever been qualified as an expert. In direct, she did explain that these type of cases are probably extremely rare. It's not often, as she explained, she would go and have to do an autopsy and a police officer would come in and say, you know, unfortunately, our police dog attacked this person, or we were called to a scene to investigate a dog attack. So not very often would she have to come to the opinion that it was a dog attack. This is a unique situation. But with the amount of autopsies that she has done with dog bites, I would say she is overly qualified to testify in this case.
Al, you know, it's a double-edged sword with expert witnesses, because there are those, like if we pull back the curtain, there are professional expert witnesses out there, and that's all they do, right? They don't actually practice anything. They just get ready for the next case where they're going to be an expert in. So, you know, the fact that you haven't testified before, much like the brain surgeon for the prosecution, who had limited experience as an expert because he's operating on brains, that made him more credible. Did she survive cross-examination?
Well, one thing in this instance, as she didn't do last time, is that she prepared a report, which was why Brennan was able to do what he did with regards to picking on her when she was testifying, which I thought he did a very good job on that. Look, the no depth, no punctures, I think is a big problem for the defense with regards to what she is stating. I mean, that would be the key. You would see puncture wounds, you would see depth. These are superficial wounds.
Well, let me ask you this, Al, and just being a devil's advocate here, okay? I'm not picking on you. I'm not picking on you, Al. But a broken taillight, a broken taillight on an SUV that's going 24 miles an hour with those sharp edges, apparently they didn't pierce the skin either. I mean, he was wearing long sleeves.
Right. He was wearing long sleeves, but even that long sleeves on a canine, the teeth are going to make some sort of a bite. They're going to have
How
something.
about 6,000 pounds of an SUV and a broken taillight going 24 miles an hour? Would that perhaps pierce the skin too?
Well,
I'm just being a devil's advocate.
There's a good chance that possibly that is an argument that could be raised. Unfortunately, they're not raising that argument. They're raising the fact that this was an attack by a canine, that he was beaten up and then attacked by a dog and then thrown out into the snow to die. That's what they're saying, okay? I agree with you that maybe taking a look from it and saying, is this practical that this could be done there? You know, it doesn't make a lot of sense to me on either situation, but that does not. The dog bite situation to me has been a problem. I didn't like the testimony in the first case, and I'm not crazy about it on the second case.
Gotcha.
But I am, you know, I do think that there was enough of a bite by the defense to, you know, get her out there. She makes a good witness. She looks good. She's got that, you know, that almost Matlock way of discussing things. But I'm troubled by the fact that she called in to be a witness.
Yeah,
that she wanted to grab
that's
that.
unusual.
And I've been doing this 40 years. That's never happened to me.
Well, you got to get a trial on court TV, Al. That's what you got to do. All right. When we come back, those nasty, nasty text messages from Trooper Proctor make their way inside the courtroom without Trooper Proctor.
Does it begin with comments from Mr. Proctor?
It does.
Could you read all of them, please?
These are not my words. I'm not really comfortable reading these. Do I have to say these words out loud?
So I'm going to see you at sidebar.
Oh, it's nasty. We're getting to the part of the trial where the jury's listening to those nasty text messages from Trooper Proctor. He's in this text message chain that apparently has been going on for 10 years with his buddies that he grew up with. And that's one of his friends on the witness stand, because Proctor, he's not going to testify in this case, but the defense wants those text messages in front of the jury. If there's children in the room, send them out. Let's take a listen.
On January 29, 2022, 11 p.m., 5 minutes, 57 seconds. And this page ends at 11 p.m., 6 minutes, 39 seconds on January 29, 2022, ending in numbers 3-8. Did I read that correctly?
Yes.
Mr. Proctor says, from all accounts, he didn't do a thing wrong. She's a whack job, and then uses the C word to describe. Is that accurate?
That's accurate.
He then says, yeah, she's a babe. Weird Fall River accent, though. No ass. Are those the words that he wrote?
Those are the words.
And there's a response at the bottom from one member in the group stating, oh, she's skating.
Yes.
Let's turn the page, ending in 3-9. These begin in January 29, 2022, 11:06 p.m., 55 seconds. Is that accurate?
Yes, it is.
Mr. Proctor responds, 0 chance she skated. She's effed. She's
Yes.
Is that what he said?
It is.
And then one person in the group says, no ass. Accurate?
Yes, that's accurate.
Mr. Proctor, there's a response, laughed at, quote, no ass.
Yes.
Somebody in the group says, is that chick a smoke? And then the same person follows up with a question mark. Accurate?
Accurate.
Mr. Proctor responds, E-H.
Yes.
Nut bag, as my chief would say.
Yes.
She's got a leaky balloon knot.
Yes.
Leaks poo.
Yes.
Are those the words of Mr. Proctor?
They are.
Did I read those accurately?
You did.
Wow. All right, back with us, Al Wunsch, Darnell Crossland, Paulette Lofton. Paulette, no Proctor delivering this. He read them in the first trial. It's being delivered a little differently, and the prosecutor was the one having them read and going through them. Who gets the advantage of no Proctor? Is it the prosecution or defense?
I think it's probably split, and I think that's why defense is
Another
not going
hung
to call him.
jury.
I think he's a loose cannon. Now he, obviously was let go from that position. He doesn't have any loyalty anymore. I think calling him would be detrimental for the Commonwealth and for the defense. I just don't think having the Commonwealth read the vile text messages into the record had the impact that Proctor himself reading them into the record and having defense be able to say, what did you mean by that? Why were you thinking that? Why did you put that in a text? I think that had a lot more impact than this poor middle school friend who has been brought in to, he didn't even want to read the vile text messages. Obviously, he didn't want to be there. He was uncomfortable in this group chat that he's had for 10 years. So I don't think it had the impact. But again, I think it's what they're left with because Proctor would just be a loose cannon.
Al, who got the advantage in the second trial with no Proctor?
I think the prosecution got the advantage on it because if the defense had called him, I know the prosecution was not going to, but the defense had called him, there was an opportunity for him to try to humanize his responses, talk about the fact that he was deeply upset that a brother police officer was killed, that he was, just distraught over this, and this why it was overcoming him with emotion. And that's why he was doing it. It was a stupid move. It was a childish move, but they didn't give him the opportunity to humanize or explain. And so I think that the prosecution got the leg up on this one.
Wait, that doesn't make sense, Al.
Because what I'm saying is if the defense had called him, then the prosecution would have had the opportunity to try to humanize him. The defense did not call him. They're using these text messages.
Right. But you're saying that the prosecution
are cold.
But the prosecution couldn't humanize him. So that's advantage defense.
That would have been ordinarily for the defense. But what I'm saying here is this: by doing exactly what was said here, they made them cold. They made them without any emotion. They made them plain. Okay,
the text messages.
You didn't get the excitement.
Gotcha.
The text messages.
Okay.
You wouldn't have gotten the excitement that you would have gotten with Proctor on the stand, with somebody harboring him on both sides.
Darnell, who got the advantage here, prosecution or defense? The fact that Trooper Proctor will not be a part of this trial.
Yeah, I would have to say it goes to the prosecution because there's an old trick that if there's something bad on your side, you address it. You take the win out of it. If Proctor was there, he would have to explain that his behavior was not professional. It was not part of his training. It was uncalled for. It was rude. It was vile. And then the prosecution would have to try to make good of that. and they would have to grapple with it. So now they just ran it out there and then said, let's move on. Another thing, you got to pay attention to the details. His good friend says, do I have to speak these words? They're not mine. They're just idiots. And so that alone showed that he wanted to distance himself from that. And so the jury is getting that. Like, this is so bad that this man is saying, I don't even want to repeat this stuff.
Yeah.
And so I think the prosecution got off with not having to have this dragged out. But the defense didn't lose any points either. So they got points, but the prosecution lost more points with Proctor.
Gotcha. So you're kind of on the fence. Unbelievable day. Al Wunsch, Darnell Crossland, Paulette Lofton. Great to have you aboard. See you real soon. When we come back, I'll reveal something else you need to know tonight. Plus, coming up next hour. Tonight on Vinnie Politan Investigates, Karen Reed has not testified, but she has spoken to the media outside of court and in sit-down interviews. She has told her story, but does her story make sense? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty.
There's something wrong in this county.
Come at me.
The Karen Reed murder retrial. Live coverage weekday mornings, 8, 7 Central on Court TV.
Time to reveal something else you need to know tonight. Let's take a look at what's happening in the world of crime and justice. The sex trafficking trial of Diddy Combs continues. Crucial cross-examination of his personal assistant today. Court TV legal correspondent Kelly Craft is in New York City and has the latest for us tonight.
Vinnie, we are in the 4th week of the Diddy sex trafficking trial, and today a former assistant to Sean Combs, who goes by the name of Mia for this trial, she was on the stand. When she was testifying, she kept her head down, and at one point she was even positioning herself in a way facing the jury as to not even make eye contact with Sean Combs. Defense counsel asking her about a series of text messages that she sent Combs expressing her adoration for him in spite of claiming he raped her and forced her to perform oral sex on him. She also said she witnessed Combs being physically abusive, but she testified she didn't say anything because she was, quote, brainwashed, and that she knew if she made Sean Combs happy, she would be safe. On cross-examination, defense attorney Brian Steele asked Mia if she intended to sue Sean Combs, her former boss, based on the sexual assault allegations she has made against him. Mia testified that was not her intention. The defense attorney also asked Mia if she wanted money based on her testimony at trial. She said no. On Tuesday, Eddie Garcia, a former security guard at the Intercontinental Hotel in Los Angeles, where Sean Combs is seen physically abusing his then-girlfriend Cassie Ventura, is expected to testify. Garcia has been granted immunity in exchange for his truthful testimony. Also expected to be called Brianna Bongolin, a friend of Cassie Ventura, who filed a lawsuit against Combs in 2024. She is expected to testify about Combs allegedly dangling her from a balcony. And Vinnie Court gets back underway at 9 a.m. Eastern. That's the latest from here in Lower Manhattan. We'll send it back to you, Vinnie.
Thanks to Kelly Craft. We have a missing child who needs your help. Please take a look. This is Elijah Henderson, 16 years old, missing out of Shreveport, Louisiana, has an Elijah tattoo on his forearm, maybe in the local area. If you see him, 911, 1-800-THE-LOST, or you can call the Shreveport Police Department in Louisiana. That number's on your screen right now. Don't go anywhere. We have another hour of live true crime. Vinnie Politan Investigates is next. In the meantime, please don't forget to hug the kids.